Yes, sir.
Maybe it's related to Iran sanctions. The thing is, as you know, here Chile has two main businesses. That's copper, and the other one is agropecuary. There are certain enterprises who are maybe worldwide based, but they have operations here in Chile, who, which exports fruits, for example, to Iran. So, seeing that threat, for example, in terms of the risk that it takes, that operation within the U.S. regulations, the thing is, if you were in charge of the swift sendings of wire transfers, will you take the risk to send the money to that country, or you just seeing there's a risk that the money and maybe the information of that transaction is not quite real, for example? Will you just ban all the operations with Iran in your bank, for example?
Yeah, that's a good question, because it touches on sort of different types of commerce that can have to do with Iran. And the first thing is that if you're doing business with Iran, you really want to take a very close look at the specifics of the operations. You know, I spoke at a very broad level about Iran. There are specific exemptions for food, I think for agriculture. So you want to look at those specific exemptions. If it's not in U.S. dollars, you're fine unless it has to do with petrochemical industry. So when you're talking about agriculture, the first question is, are you transacting in U.S. dollars? If the answer to that is yes, then you have to think about, is there an exemption? Who is my counterparty? And the OFAC is a very accessible and user-friendly agency. They answer questions and they grant licenses all the time. We talk to OFAC all the time on behalf of clients to get a license so that the firms can do business properly from the U.S. perspective without risk of having the transaction seized or rejected. The other really important thing is, you said, you know, something about what maybe the wire payment information wouldn't be quite real.
Yeah.
I would counsel strongly not to do that, because I can almost guarantee that someone somewhere in this ever smaller world will find out about it. Someone might blow the whistle on it, and now you're going to be in a position where you may or may not have violated sanctions, but you have certainly falsified the records of the U.S. bank. So trying to avoid one possible crime or sanction, which may not be a sanction at all, then the firm would have violated another crime by sending false information to the U.S. bank. So I would not do that.
You know, Adam, it might be interesting to talk about the theory of the stripping cases, which involved exactly that, the falsification of business records in New York.
Right. So in the stripping cases, there was a couple of crimes in play. And from a federal perspective, of course, there were the violation of sanctions, and that's a federal crime. From a New York State perspective, and the reason that New York State is so relevant in this area is that all of these wire payments, almost all of them, pass through Manhattan. All of the clearing banks are in Manhattan, so these wire payments come into the United States, they go through a bank in Manhattan, and that gives Manhattan jurisdiction criminally over the payments. And the theory in New York State doesn't have a sanctions law, so actually the theory of criminal prosecution in New York State was that the foreign bank, the non-U.S. bank, in sending that false information into the U.S. bank in New York, falsified the books and records of the New York bank. So it wasn't really a sanctions criminal case under New York State law at all. It was a false books and records case.
¿Alguna otra pregunta?
Sí, yo tengo una pregunta para no demorar el micrófono. Sí, La industria bancaria en Chile, como ustedes ya deben saber, está muy preocupada de poder cumplir, ¿no es cierto?, con FATCA a partir de enero del 2014. Uno de nuestros principales problemas es el conflicto que se produce entre la legislación chilena y FATCA, específicamente por cuanto nosotros no tenemos, o aún tenemos una ley de secreto bancario que nos permite, que no nos permite revelar todos los antecedentes de nuestros clientes respecto de su situación financiera. Ahora, además, nosotros no tenemos contacto hoy día todavía con el Servicio de Impuestos Internos o el par del IRS en Estados Unidos como para saber qué determinación se está tomando. Entonces mi pregunta es, ¿cómo ven ustedes que Chile va a poder cumplir con FATCA bajo estas condiciones, si acaso y no vamos a estar en condiciones de poder retener, como tendríamos que hacer en enero de 2014, a algunos de nuestros clientes, al onboarding específicamente o a los recalcitrantes? ¿Cómo poder retenerles si existiera ese conflicto legal?
It's a complicated issue. I would say that under the models that the U.S. government is using to strike agreements with particular jurisdictions, in jurisdictions that have stronger bank secrecy requirements, the IRS is seeking one of the model type agreements, seeks in substance a waiver of bank secrecy provisions. That itself obviously creates tensions within any number of jurisdictions and will pose a significant challenge to the worldwide implementation of FATCA. To the extent that I can recognize that it's an issue, like you do, we're on the same page. Perhaps to the extent that I don't think either of us sees a particular solution right now, we are likely on the same page as well. And I think that this is one of the most important issues that will be worked out jurisdiction by jurisdiction as the U.S. tries to apply this.
This is also an area where we're engaged with and following closely what the Department of the Treasury is doing. There's a small group within the Treasury Department that is working on this issue and on an international basis going to various jurisdictions to try to come up with solutions that work for both countries. Because while there is an assertion, clearly an assertion of U.S. law in an extraterritorial manner, the United States recognizes that tension between foreign banks, non-U.S. bank secrecy, and this U.S. Requirement. And so at a sort of government-to-government level, they're following it. And we're just trying to keep very closely attuned to it so that we can advise clients, foreign, non-U.S. financial institutions, how to, what's going on and what to expect.
Una pregunta para acá.
Good morning. One of your remarks was that choosing the currency of the transaction nowadays really matters. You mentioned that if you choose US dollars, definitely it's going to come within the scope of US regulations. My concern is, okay, we move to euros or other currency like from, I don't know, China. But in Europe, I learned that also there is some strict regulations on these things. We have here in Chile, Santander, and a lot of international banks. What can you tell us? I know that you are a U.S. expert in regulations, but what are the similarities of those regulations with, let's say, Europe or Germany or Spain?
All of those jurisdictions, all of the European jurisdictions have enacted certain sanctions. There's been EU sanctions that have been implemented by the EU member states. The UN sanctions apply, and I think that what we see as a best practice in the United States is that it's not just when U.S. banks are screening their automated lists, it's not just the OFAC list, it's all of the lists, because they're not co-equal, they're not co-extensive. Certain entities have been designated as concern for terror finance or narcotics finance or money laundering by the UN that have not been designated by the U.S. And of course, certain countries or persons, companies have been designated by the U.S. and not by the UN or the EU. So they're not coextensive. What's important in terms of having an effective sanctions compliance program is to make sure that when the firm is conducting international payments, it screens against all of those lists to look for the entities or the individuals that have been designated by any jurisdiction as of concern for money laundering, terror finance, weapons of mass destruction, proliferation. I think that's very important. It's a great point.
From the perspective of a U.S. prosecutor, a bank that has different standards for U.S. dollar transactions and euro transactions and other currency transactions will be seeing something as, okay, your level of compliance is low because you are putting different standards for this.
I think a U.S. prosecutor would look at it that way, but the U.S. prosecutor only has jurisdiction if you have violated U.S. law. There's another point of concern, though, and that is that if a bank, for example, decided that it would have one standard for the U.S. and then do a lot of Iranian business in euros or in Chinese renminbi or any other currency, beyond the criminal jurisdiction, the Treasury Department has the authority to designate that bank as being a concern for money laundering or sanctions violations and take steps to limit or take away that bank's access to the U.S. financial system. So it's a different problem. It's not a criminal problem. It's a sanction. It's a policy problem, and the result is the same. It's limited or revoked access to the United States. So I wouldn't play too cute with that particular game.
Una pregunta en público. Por allá.
Hi, I want to know your opinion about the following. When we are managing a compliance problem, we need to do that by a risk approach. Okay. And now I want to know about FATCA, because FATCA is, I believe, is looking at other things. They are using us as a tool to increase tax contribution. And maybe we are going to lose something because of that.
One of the major criticisms of FATCA is that it makes the non-U.S. jurisdiction an unpaid employee of the American Revenue Service, and I think that's a criticism that holds a significant degree of water in non-U.S. jurisdictions. With respect to it being a risk-based approach, I think another criticism of the FATCA structure is that it decidedly is not. If you look at your compliance program within an institution, and you're able to assess what your risks are, and say my risks are 1, 2, and 3 in descending order of importance, you're encouraged to spend more time looking at 1, then 2, and then 3. FATCA is the exact reverse of that. It is not asking you to assess your risk and to spend more time on any particular subject. It requires you to screen your entire account system for one particular bit of information, that being the link to the United States. So it is a compliance structure that is not risk-based. It requires a look across the entire account database in a very different way. So,
You're right.
Yeah.
The problem is we need to see other things. I agree the U.S. pesos are not a risk of money laundering.
No, it's not money laundering. It's all about tax.
But they are using KYC,
correct.
and
Yes.
we are in the middle.
Agreed.
Well, maybe the point is that we have to spend a lot of money to implement FATCA in banks, and we're not seeing any, for let's say, support from United States to implement, or maybe you get granted not to be taking the 30% of your incomes.
Yeah,
I know it's maybe that's the point of this.
But I guess the only comment I would make is it's not such a deep, thorough screen. It's a pretty superficial. Is this a U.S. person, a U.S. taxpayer? So it's less deep a dive, but it's a very wide survey.
Look, and I think the hope is that foreign financial institutions, given the international norms towards KYC, if you look at the FATF guidance, for example, there are know your customer requirements that likely, if applied evenly in the institution, could be leveraged to deal with the FATCA requirements. I think that's the hope. I also think that there's a distinction in what's being asked, so we agree, but I'm offering the other side of the coin, so to speak.
Well, and the only other thing that I would say about it is, there's been a long-standing debate about the role of the developed countries in terms of providing a place for capital flight and tax evasion from developing nations.
In worldwide sense.
Yeah. And so, this goes back to after World War II, when there were discussions about it, and you have often wealthy taxpayers in the United States sending their bank accounts to Switzerland or Cayman. Then you have wealthy people in Chile or Argentina sending their accounts to the United States.
Yeah, so
And so there's a
sort of coming back and forth.
Yeah, so maybe it's a global standard of you have to pay
It's
your
probably
taxes.
more like a anti-money laundering case in terms of, well, United States overseas, and that's not corruption, money laundering in each country and worldwide with imposition of this legislation, for example. And probably Chile will get benefits of that in putting those same legislations obliged by the United States, but in terms of Chile will earn something about that. And probably in terms of FATCA, it's the same.
So
Probably.
we're both taking the different sides of the coin.
¿Alguien más? ¿Una pregunta? Bueno, si es así, tengo que darle todas las gracias a los expositores, a Adam Kaufmann y a Middlemiss, así como a todas las personas que han venido y asistido a este interesante seminario. A continuación, les voy a ceder la palabra a don Rodrigo Avellán, quien hará algunas últimas precisiones.
Rodrigo, no, yo no soy Rodrigo Avellán, soy Rodrigo Novoa, de la Universidad Mayor. Y Rodrigo ayer me informó a última hora que lamentablemente tuvo un cáncer, como dijo Ricardo Mate, no va a poder estar. Pero a nombre de él y de todos los organizadores, especialmente de la Asociación de Bancos, queremos agradecerle por habernos recibido hoy día, a la Universidad Mayor, a Andrés Chamorro, que está ahí, que fue uno de los principales orquestadores de todo esto que están viendo, y AmCham y nuestra firma Saldivia Contreras Glass y Verdugo. Les agradece por estar aquí y esperamos en algún futuro poder seguir desarrollando este tipo de actividades. Muchas gracias.